The says today's appearance could see a bail application as well as a date being set for sentencing procedures for his murder conviction. Pistorious is currently on parole under house arrest after serving jail time for culpable homicide. That judgment was changed to murder last week on appeal. Pistorious faces the prospect of 15 years behind bars. The state has not said whether it will oppose bail. Pistorious' legal team could meanwhile indicate whether he will appeal his murder conviction in the Constitutional Court. Now, for more on today's court bail hearing, we cross live to our reporter outside the High Court in Pretoria, Griselda Lewis, who I believe is joined by a lawyer. Griselda, it's over to you.
Well, thank you very much, Leanne. Well, certainly very crucial this morning, exactly what you said, whether Oscar Pistorious' lawyers will inform this court if they plan to appeal the murder conviction. Of course, that last week the Supreme Court of Appeal had overturned that culpable homicide conviction, saying that initially Oscar Pistorious should have been found guilty and that he foresaw that he would have killed someone when he fired those shots through his bathroom door on that Valentine's Day. Just to unpack the expectation on whether there is a constitutional matter in this case, I'm joined now by Dr. Llewellyn Kerr-Lewis, who's been chatting to us throughout the trial, of course, and as well as in Bloemfontein, about the possibilities. Doc, on everybody's lips this morning is whether Oscar Pistorious' lawyers will inform this court if they plan to appeal the murder conviction. Is there a constitutional issue here that the Constitutional Court, I guess, can hear?
First of all, the purpose of today's proceeding is obviously only to get rid of the lacuna that exists, academically speaking, in law, regarding the position and the status of Oscar Pistorious pending the sentencing that must take place somewhere in the new year. So it's a storm in a teacup, so to speak. I cannot see any problem with setting bail. Obviously, stringent bail conditions will be set to secure his attendance at court when the sentencing starts. Any indication of an appeal to the Constitutional Court at this stage of the proceedings might be considered to be premature. I suppose they can raise it and they can mention that consideration, but seriously, consideration can only be done after sentencing has taken place and the matter at hand, in actual fact, finalized. That is the right time to do so. On the assumption that they do consider lodging an appeal, there are only two procedures to follow. They must get leave to appeal to the Constitutional Court first of all, which will not easily be granted since a unanimous verdict was handed down by the Supreme Court of Appeal, first of all. Or alternatively, they must, by means of what we call a petition procedure, approach the Chief Justice directly. Those are the two options available. A constitutional principle must be infringed upon. One might say that the mere fact that the media was allowed access to the courts and that witnesses was influenced indirectly or unduly, that might be considered the constitutional issue at stake, which they might take as the point of departure.
But wouldn't the argument, I guess, then be that that issue should have been raised by the defense, first of all, when Judge Mlambo had handed down a verdict, if I may, that the media is allowed to cover the proceedings?
Quite correct. Judge President Malambo is a very senior judge. Obviously, at the time when the judgment was handed down, the defense had the prerogative and the opportunity to appeal that judgment. In other words, to say, but listen, we're not satisfied. He did not consider all the constitutional principles. In his judgment, it's quite clear that he had a balancing judgment. He considered constitutional principles. He considered the right of the accused to a fair trial. He considered issues of freedom of speech, access to the public, media freedom, etc. And one will raise the question, but why didn't you, defense, at that stage, then raise the question? Obviously, the issues that came about during the trial might be considered to have been developed afterwards, after the judgment has been handed down. But I do think it's getting more difficult for the defense. Every time you appeal to a higher authority, it's getting more and more difficult.
Right, let me just hold on with you, Dr. Kerr-Lewis. I think somebody, one of the interested parties in this matter is coming. If I could just let you face that way. Let's see who is coming. As you can see, they're walking into court at the moment is Barry Rue. Of course, Oscar Pistorious' lawyer coming into court here this morning, of course, for that bail application, and certainly something that we'll also hear is a possible date, of course, for those sentencing arguments in mitigation and aggravation of sentences. If you could come back to us there again, Dr. Kerr-Lewis. On the issue of the constitutional matter which might be brought up, could perhaps the defence argue that they could not have foreseen the massive media contingent that there was? You'd recall Oscar Pistorious was painted as a poor witness, and of course there's also the other issue of the other witnesses who might have been influenced as a result of the live coverage that we saw.
You're quite correct, Christelda. The fact of the matter is they've got nothing to lose, so to speak. In other words, any opportunity and reason to lodge an appeal to our highest court must be considered. I can surely think of a number of reasons why they might be inclined to try their luck at the Constitutional Court. The line that you've just mentioned is probably the best argument under the circumstances, because it directly have a bearing on a person's right to have a fair trial. And if they can convince the Constitutional Court that he did not have a fair trial, well, then it's up to the Constitutional Court then to make the necessary corrections as far as that is concerned. It is, however, and I must reiterate that, a very, very difficult route to follow. The Constitutional Court does not eagerly intervene at the Supreme Court of Appeal's judgments, especially where it was a unanimous verdict.
Yes.
On law, they were sound as far as I'm concerned. Whether from a constitutional principle and constitutionally speaking, there might be one or two other issues to consider. You've mentioned one. I can think of another one, for example. The fact that he was let out on correctional supervision, in other words, got out of jail basically, although under house arrest still and other correctional obligations. The question is now to suddenly once again put him back in jail. Isn't that also against constitutional principles, human rights, etc.? Those are the kind of issues that they will debate. And I do see that we might be in for another round.
All right. About 15 days for the defence, I guess, to file those papers, if indeed that's what will happen?
We should not confine ourselves to the strict compliance to the court dates as such. Remember that the courts are in recess currently, so they are basically on holiday until mid-January, end of January. So there are no obligatory court dates that is counting. Once that starts, then there obviously are rules to adhere to.
It usually is 14 to
Correct.
15 days, but because of recess.
And remember, you can always apply for condonation for the late filing of your application, and that is eagerly granted on the assumption that you've got good reasons to do so. The mere fact that we are on the December and January holidays should be sufficient reason for the judges to also grant condonation if it's a day or two late. So we shouldn't be too strict with regard to that aspect. But once again, I must also reiterate, the right time to do so, to consider lodging an appeal to the CC, is only after the sentencing has been finalised and the matter in the High Court Pretoria finalised once and for all. That is the right time to do so, not now.
And certainly that might look like we might get that date somewhere next year, probably next year. Well, certainly there you have it. Thank you very much to Dr. Llewellyn Kerr-Lewis, always very insightful there. Unlikely, Leanne, that we'll get a date for those sentencing arguments this year, likely to sit next year, but certainly we'll get the definite date at 9:30 when those proceedings get underway. We're still waiting for Oscar Pistorious to arrive here at court, but already we saw his lawyer Barry Roo enter court just a few minutes ago.
Christelda Lewis, thank you again for the update throughout the morning. And remember that Christelda Lewis will be updating us again in Newsroom. And that's when the Oscar Pistorious trial is expected to get underway. We're talking about 9:30 this morning. So we'll certainly be there with our cameras live, capturing everything that you need to know.